And Senator Grassley.
Thank you, Mr. Chairman. After much deliberation, I've concluded that I cannot support the nomination of Judge Sotomayor to be Associate Justice. The Senate must confirm to the Supreme Court individuals who possess a superior intellect, distinguished legal experience, unquestioned integrity, and even judicial demeanor and temperament. More importantly, the Senate has a tremendous responsibility to confirm individuals who truly understand the proper role of justice as envisioned in the Constitution. This is the most critical qualification of a Supreme Court justice, the capacity to faithfully interpret the law and Constitution without personal bias or prejudice. Our system of checks and balances demands that judges not take on the role of policymakers. That's because our great American tradition of checks and balances envisions that political and social battles be fought in the legislature, not the judicial branch of government. Further, our American legal system requires that judges check their biases, personal preferences, and politics at the door of the courthouse. Just as Lady Justice stands before the Supreme Court blindfolded, judges and justices must wear blindfolds when they interpret the Constitution and administer justice. I've been a member of the Senate Judiciary Committee since 1981 and have voted to confirm both Republican and Democrat presidents' picks for the Supreme Court using this standard. Unfortunately, I believe that Judge Sotomayor's performance at her Judiciary Committee confirmation hearing left me with more questions than answers. It is imperative that the nominee persuade us that he or she will be able to set aside one's own feelings so he or she can dispassionately administer equal justice. Yet, I am not convinced that Judge Sotomayor has the ability to wear the judicial blindfold and resist having personal biases and preferences dictate her judicial method on the Supreme Court. President Obama clearly believes Judge Sotomayor measures up to his empathy standard, which encourages judges to make use of personal politics, feelings, and preferences. This radical empathy standard stands in stark opposition to what most of us understand to be the role of the judiciary. To her credit, at the hearing, Judge Sotomayor repudiated President Obama's empathy standard, but Sotomayor's record, both in and out of the courtroom, revealed to me a judicial philosophy that bestows a pivotal role to personal preference and beliefs in her judicial method. In speeches she gave and law review articles she wrote over the years, Judge Sotomayor doubted that a judge could ever be truly impartial. She argued that it would be, quote, a disservice both to the law and to society, unquote, for judges to disregard personal views shaped by one's, quote, differences as women are men of color, end of quote. She proclaimed that the Court of Appeals is where, quote, unquote, policy is made. She said that a wise, quote, a wise Latina would more often than not reach a better conclusion than a white male, end of quote, and disagreed with a statement by Justice O'Connor where Justice O'Connor said, quote, a wise old woman or a wise old man would eventually reach the same conclusion in a case, end of quote. She said that judges should look to foreign law so that they can get, quote unquote, creative juices flowing. At her confirmation hearing, Judge Sotomayor attempted to explain these statements away. However, I had problems harmonizing her answers with the statements that she repeated over and over again throughout the years. The statements made at the hearing and those made in speeches and law review articles outside the hearing are, in my mind, polar opposites of each other. They're not compatible and cannot be reconciled. I also question the reliability of statements made at a formal hearing where the nominee is clearly prepared to answer questions as compared to statements that were made over the years in any unguarded manner without any restrictions and without a set goal in mind, that being confirmation to the judicial branch. In addition, Judge Sotomayor's record on the bench raises serious concerns. Hard questions, her hard cases say the most about a judge, and we all know the Supreme Court takes on only hard cases. Well, those are the cases that raise the most concern with this nominee and what she will do if she is confirmed. First, her record before the Supreme Court is not a particularly impressive one. She was reversed 8 out of 10 times and was criticized another one of those 10 cases. So the Supreme Court disagreed with her 9 out of 10 times. In addition, some of her cases raise questions about whether she will adequately protect the Second Amendment's right to bear arms and the Fifth Amendment property rights. Statements she made at the hearing raised concerns that she will inappropriately create or expand rights under the Constitution. Further, some of her cases raise questions about whether she will impose her personal policy decisions instead of those of the legislative branch or executive branch. At her confirmation hearings, Judge Sotomayor was questioned at length about her understanding of rights under the Constitution, including the Second and Fifth Amendments and the right to privacy, and raised and the rationale for her decisions in Rishi, Maloney, and Didden, and other cases. She was also asked about how she views precedent and how she applies it in cases before her. Unfortunately, I wasn't satisfied Judge Sotomayor's responses about her cases or her general understanding of rights under the U.S. Constitution. Moreover, I wasn't assured of Judge Sotomayor would disregard her strong personal sympathies and prejudices when ruling on hard cases dealing with the important constitutional issues. For example, I wasn't persuaded by Judge Sotomayor's claim that she followed precedent in Rishi, nor her explanation as to why she could dismiss such a significant case with absolutely no legal analysis. I was concerned with Judge Sotomayor's explanation of her decision in Maloney, holding that the Second Amendment is not fundamental, and her refusal at the hearing to affirm the Americans have a right of self-defense. If Maloney is upheld by the Supreme Court, the Second Amendment will not apply against state and local governments, thus permitting potentially unrestricted limitations on this important constitutional right. I was troubled with Judge Sotomayor's failure to understand that her decision in Didden dramatically and inappropriately expands the ability of state, local, and federal governments to seize private property, and she mischaracterized the Supreme Court's holding in Kelo. Judge Sotomayor's discussion of landmark Supreme Court cases and her own decision on the Second Circuit did not convince me that she understands the rights given to Americans under the Constitution or will refrain from expanding or restricting those rights based upon personal preferences. Nor was I persuaded that the judge will not allow those personal beliefs or preferences to steer her judicial methods and outcomes of cases. At her confirmation hearing almost 2 decades ago, then Judge Souter, or at his confirmation hearing, I want to refer to Judge Souter, speaking about filling vacuums in the law. This is something I brought up with her. That concept greatly worries me because courts should never fill voids in the law left by Congress. Judge Souter's decision on the Supreme Court, I believe, demonstrates that he does believe courts do indeed fill vacuums in the law, and in the only case of voting for a Supreme Court judge, either by a Republican or Democrat, I've regretted my vote to confirm him ever since. So I've asked several Supreme Court nominees about courts filling vacuums at their hearings. Judge Sotomayor's lukewarm answer left me with the same pit in my stomach that I've had with Justice Souter's rulings that I had hoped to have cured with his retirement. And it reinforces my concerns with her hearing testimony, cases, and speeches. In conclusion, all judges must have a healthy respect for constitutional separation of powers and judicial restraint. All judges must be bound by the words of the constitutional legal precedent. However, Supreme Court judges are in a very special position with respect to their decision-making process. The Supreme Court has the final say on the law. Justices on the Supreme Court have fewer constraints on their judging than judges on the district or appellate court. So it's critical that we ensure nominees to the Supreme Court will resist the temptation to mold the Constitution to personal beliefs. As one witness testified at the hearing, the judicial restraint of the Supreme Court justice is self-restraint. She's a remarkable woman. She's a talented individual, woman of substance and personality, a trailblazer. There's no doubt of her intelligence, integrity, or distinguished legal background. We're proud of those accomplishments. However, I don't believe that the judges possesses a critical ingredient of Supreme Court justices. Unfortunately, I'm not convinced that Judge Sotomayor will be able to set aside her personal biases and prejudices and decide cases in an impartial manner based upon the Constitution. I'm not convinced that Judge Sotomayor will protect important constitutional rights, and nor am I convinced that she will refrain from creating new rights under the Constitution. I'm not convinced that Judge Sotomayor understands the proper role of a judge in our system of checks and balances. Only time will tell which Judge Sotomayor will sit on the Supreme Court. Is it the judge who proclaims that the Court of Appeals is where policy is made? Is it the judge, or is it the nominee who pledged fidelity to the law? Is it the judge who disagreed with Justice O'Connor's statement that a wise woman and a wise man will ultimately reach the same decision? Or is it the nominee who rejected President Obama's empathy standard? Only time will tell, and I hope that I'm wrong on this vote, but I think based upon what I saw Judge Souter do and where she's coming from, I think I'm right by voting no.